Calificas para ser legal. ¿Quieres saber? Solo llama al abogado Andrés Mejer.
DACA is safe. For now. You may have heard the amazing news that we received from the Supreme Court last Thursday, 18th of June 2020 about DACA. Supreme Court said that the Trump administration could not end DACA, at least not the way that they did. On tonight's live show, I'm going to explain a decision that was published by the Supreme Court, what it means for those that have DACA or may be eligible to apply, and what I think will happen going forward. I'll also explain the 7 requirements you must meet to be eligible for DACA. If time allows, I will answer any questions. I know it's been a long time since we've last talked about DACA in any substantive way. That's because, September 15, 2017, Trump administration under Jeff Sessions said, no more DACA, just like that. So it's been almost 3 years. It's a good time to revisit because now time's an issue. If you're eligible, you should apply right away, and I'll explain what that process looks like. I'm Andrés Mejer, published author, public speaker, and immigration attorney. Thank you for joining us on the English version of our show, Para Ser Legal, our weekly show, To Be Legal. So first, let me give you a little history about DACA. Now, the DACA memorandum went into effect in 2012 after decades of Congress being unable to pass the DREAM Act. The DREAM Act stands for Development, Relief, and Education for Alien Minors. The DREAM Act was bipartisan. In case you guys don't know what that means because it's been so long, it means congressmen from both parties developed the plan and agreed that it should be passed. Oh, can we even remember those days? Now, if the DREAM Act had passed as it was written in 2001, it would have allowed people who came to the U.S. as children to gain legal status, and ultimately their green card and citizenship. Now, DACA does not give legal status to the people who have it. That means they will not get a green card or become a citizen as a DACA recipient without some other process. DACA only says it protects them from deportation, and if they meet certain strict requirements, they're going to get work authorization as well as access to certain government benefits. Now, how did this most recent court battle start? Well, most people don't know, but there was another executive order like DACA called DAPA. Now, DAPA stands for Deferred Action for Parents of Americans. DAPA would have given deferred status to the parents of U.S. citizens or lawful permanent residents. Again, just like DACA, it would not have given legal status. It merely gives protection of deportation, and obviously if you meet certain criteria, you get work authorization. Now, does it seem strange to anyone else that Trump and his followers are against giving anyone who's in the U.S. permission to work legally? Who would have thunk, huh? So DAPA was announced by President Obama in November 2014, and by February 2015, several states had filed a lawsuit against it in Texas in the 5th Circuit, and a judge there, Judge Andrews, if I'm not mistaken, issued an order stopping the implementation of DAPA. In June 2017, after Trump took over, won the presidency, he announced that he would be rescinding the DAPA order. At the same time, Acting Director of Homeland Security then was Elaine C. Duke. Her role ended in April 2018. She decided to terminate DACA based on advice from Attorney General Jeff Sessions. Now, Duke said that the Department of Homeland Security, DHS, would not accept any new DACA applications, but those who had DACA at the time could apply for a two-year renewal. They also eliminated Advance Parole immediately. When DHS said that they were ending DACA, several groups sued, saying, hey, this violated the Administrative Procedures Act, which, by the way, is the same argument that the states made against DAPA. If it works, keep on using it against, huh? So the group said, hey, listen, the way you eliminated DACA violates the rules, Administrative Procedure Act, and it was arbitrary and capricious, and it infringed on the Equal Protection Clause of the Fifth Amendment. Now, the Department of Homeland Security argued that they weren't bound by the Administrative Procedures Act at all. And they say under the Immigration and Naturalization Act, courts had no jurisdiction to tell them what they can and can't do regarding programs like DACA. Absolute positions. That's Trump. Every court who heard the subject agreed that the elimination of DACA was wrong. But they differed in reasons to what DHS did that was wrong. They did, however, issue an injunction, meaning they stopped Trump from completely eliminating DACA. DHS, now in the district court, that judge gave DHS an opportunity to issue a new memorandum as to why DACA should be rescinded. Then DHS Secretary Christine Nielsen, who had succeeded Ms. Duke until, of course, she resigned April 2019. So she submitted an answer to the district court's request, but Ms. Nielsen did not provide any new arguments. She just explained why she thought the previous decision was sound and included new justifications for the rescission. The district court refused to allow to be ended with this new argument because they said, listen, this isn't a new argument at all. It's the same argument you provided us before, and for that reason, district court said, we don't like the way you did it. Trump administration then appealed these decisions to the Second Circuit, Ninth Circuit, and the district court circuit, as well as asking the Supreme Court to get involved through a process called certiorari. Now, when the Ninth Circuit affirmed the lower court decision, so lower court decision stopped the stopping of DACA, the appellate court agreed and continued the stopping of DACA. I know it's confusing, double negatives, not so often that we use it in English. Now, when the Supreme Court affirmed, Trump administrator said, let's go to the Supreme Court again. So the Supreme Court accepted the case, and again, we got the decision just last week. So what were they looking at? Well, first question is, hey, is this decision reviewable by the Administrative Procedures Act? And if so, was the rescission arbitrary and capricious in violation of the Administrative Procedures Act? And lastly, did the Trump administration violate the plaintiff's equal protection claim? Those were the three issues before the court. Now, what did the Supreme Court decide? Well, first of all, the Department of Homeland Security, Supreme Court said, hey, DHS's decision is reviewable under the Administrative Procedures Act. That's huge. Now, I've talked about these issues in the past in a prior video of what the three issues that the Supreme Court was discussing. So now, I just want to give you a little highlights. So, DHS's decision is reviewable under the Administrative Procedures Act. It said that DACA creation is an action that provides a focus for judicial review, which means it falls under the Administrative Procedures Act. Now, since DACA allows recipient to obtain work authorization, Medicare, and Social Security, these benefits are interests the courts are often called upon to protect. That's a direct quote. Now, the government tried to say, hey, under the Immigration and Naturalization Act, the court has no jurisdiction to hear this at all. Well, the Supreme Court did not agree, shot down those arguments. They're technical in nature, and it's not relevant to you guys, so I'm not going to go into details of what what code provisions the court relied on to say, hey, this is reviewable by the court. Trust me, you're not interested. The important part is it's reviewable, and the court made a decision. Now, the second part is, so first, court said, hey, this falls under our jurisdiction. We can review this. Secondly, you government acted in an arbitrary and capricious manner. Ho, big deal. So why is that? Now, Supreme Court said if the DHS secretary had focused on ending benefits, work authorization, but allowing for deferred action, protection from deportation, the court said they probably would have allowed DHS to end DACA the way that they did it. But since DHS kept on focusing on ending both work authorization and protection from deportation, they went beyond what was allowed and offered no reasoned analysis for doing so. They just said, we can, period. And the Supreme Court said, it doesn't work that way. So DHS also failed to address whether there was a legitimate reliance on DACA memorandum in Secretary Duke's decision. In other words, Dreamers relied on the government's promise. Now they should be punished for it. They said, hey, here I am. They pay taxes. They said where they are and what they do, and they put themselves at risk because the government said they were going to accept that. Now, DHS has to at least consider their reliance and try to minimize the harm to them. They didn't do any of that, and for that reason, it was arbitrary and capricious. Now, thirdly, the court said it is not an Equal Protection Clause violation What's the group? How is one group treated differently than the others? There are immigrants who are U.S. citizens. There are immigrants that are green card holders. And then there are immigrants who are filing for DACA. They're not limited to one country or one area. It's not limited to male or female. So, equal protection of the law was kind of a difficult argument to make. I understood why they did it. It's a constitutional question. It got it before the court. It got it into federal court. But, I never thought it was a winning argument. So what does this mean now? What this means is Chief Justice wrote that everyone agrees DHS can rescind DACA. What they said is, hey, the parties in each of the cases, in the lower courts and to the Supreme Court, admitted the president can create such a program. He has the authority, and the president can eliminate such a program. He has that authority too. So that was not in dispute. The dispute was about the procedure they followed to do it. So that means there's going to be one of two directions in the future. One, if DHS follows the steps set out by the Supreme Court, they can successfully end DACA. Two, this decision has sent the matter back to the lower courts so that may delay action while the government reworks their strategy to end DACA. In other words, they hit the reset button. So now the Supreme Court said, hey, you do the following, you can end the program. Will the Trump administration do so? Only time will tell. My assumption is they would. Now, we are in June. There is an election in November, 5-6 months away. Do I think it's going to happen before then? No, I don't believe it's going to work that quickly because there are certain time restrictions in what they have to do. But if Trump wins re-election, you better believe he's going to get rid of DACA. And by the way, TPS will follow suit also. Now, applying for DACA. If you are eligible and you don't have DACA, I would urge you to apply now. The elimination, when the Supreme Court said, what you did in September 2017, not valid, that essentially goes back to what it was before that decision, meaning you can apply for DACA and you can apply for advance parole. A little bit more about advance parole soon. Now, why apply for DACA if it doesn't give you legal status? Well, first of all, hey, it does give you work authorization. Secondly, it does give you protection from deportation. So that's kind of a big deal. Now, DACA keeps you from accruing unlawful presence. In some circumstances, unlawful presence can keep you from getting your green card. I have previously discussed the 3 and 10 year bars. That essentially happens when you consular process, when someone's filing for you, let's say your spouse, who's a U.S. citizen, but since you entered without permission when you were younger, you can't change your status in the U.S., you need to leave. Well, the moment you leave, you've now triggered the 3 and 10 or 10 year bar because you've had more than 180 days as an adult in the U.S. without permission. For purpose of this analysis, we're talking about if you're over 18. So if you're 18 years old and 2 months when you get DACA, you don't have 180 days as long as you've maintained DACA throughout that time. If you're 25 now and you never had DACA but you qualify, well, you've been here 7 years without permission, assuming you were here when you were 18. So when you leave, that bar is triggered. Now, if you have DACA while you don't have legal status, you are not accruing unlawful presence. So if you have less than 180 days when you get DACA, congratulations, you're considered to not have gotten 180 days, which means it's one less thing you need to worry about that could make you ineligible in the future. Now, the Supreme Court decision will force USCIS to allow DACA recipients to apply for advance parole, which gives them permission to leave and re-enter the country. And that is huge. Advance parole means you get permission before you leave the U.S. to be able to re-enter the U.S. Now, the requirements were you can't just leave when you feel like it. You have to file for advance parole. It has to be for humanitarian, education, or job-related reasons, not just for whatever reason. It's really specific to those 3 things. You apply. If you're approved, you can leave, and then you can come back. Now that you came back, you've been admitted and inspected, so you now have legal entry. So if your spouse is a U.S. citizen, or will be in the future, or if you have a child who's 21 and who's born here and is 21 or will be 21 in the future, now you have an immediate relative and you have legal entry. That means within a year, you can get your green card inside the United States. So it is a vehicle to assist in the process. DACA and advance parole alone ain't enough. You need someone who's going to file for you. So legal entry is a big deal. And if you have DACA and you did not initially enter legally, and you never filed for advance parole, do so now. Don't wait. Again, Trump almost certainly will try to get rid of this. While you can file for it, you should. Now, what are the 7 requirements that makes you eligible for DACA? Let's talk about it. 1, you had to have entered the U.S. before you were 16 years old. 2, you must be under 31 years old or younger on June 15, 2012. If memory serves, it means you have to have been born after 1981. 3, you must have lived in the U.S. continuously from June 15, 2007 until now. Hey, don't forget, this program was initiated in 2012. Back then, it was a 5-year look period. Now we're in 2020. That means you now have to prove you've been in the United States for over 13 years. That is a lot more than, cancellation of removal, for example, only asks 10 years. Here you need 13 and counting. 4, you must have been physically inside the U.S. on June 15, 2012. 5, you must have been here without legal status on that day, because if you did, then you didn't need this program. 6, you must have been in school, have graduated from high school, enrolled in college, have your GED or getting your GED. So basically you're in high school or you got your high school degree, or you're in school now working towards to get your high school degree like the GED. Guys, if you were working on your GED 13 years ago and you still haven't gotten it, you might have a problem. The criteria says in school, but you must have made some reasonable progress throughout this time. And under this administration, don't be surprised if they give you a hard time. Lastly, you can't have committed a serious crime, which is considered a serious misdemeanor, or 3 or more misdemeanors. Now, DUI, automatic disqualifier. Domestic violence, automatic disqualifier. Drug possession, automatic disqualifier. So a serious crime, a serious misdemeanor is the broadest standard that we have in immigration, meaning it's the easiest to get denied because of a criminal past that even the state where you were convicted might not consider it serious. But since immigration is federal, they look at it from the federal perspective, and under federal law, your crime would be a lot more serious than the court in your state that convicted you. Let me give you an example. In New Jersey, DUI is a traffic offense. Now, I'm not minimizing a DUI. The consequence could be significant. You could have fees of over $10,000. You can lose your license. You can lose your job. You can go to jail. So I'm not minimizing a DUI. I'm just suggesting that in New Jersey, it is not a jury trial. It is dealt with in municipal court, and it is considered a traffic offense. Albeit a traffic offense with serious consequences, but still a traffic offense. So immigration, because there's 50 states, the majority of those states consider DUI a felony, so does immigration. Now, it's very important to remind everyone, DACA is not a path to legal status alone. If you have DACA, we highly recommend that you contact an attorney. You may be eligible for obtaining a permanent legal status. DACA has made it so you will not be deported if you meet certain criteria, and you renew it every 2 years. However, now that Trump knows how we can get rid of DACA, we can only believe this will happen sooner rather than later. Don't wait. If you don't have DACA but are eligible, we are recommending you submit your application now. Now look, in the next week or so, there's going to be details of what USCIS is going to do, but I'm suggesting you don't wait. Submitting your application puts you in line when they start processing them, particularly since immigration has been closed for 3 months. If you don't know if you're eligible, call us. We can help you determine that. Remember, fees are increasing, everything is taking longer to process, so get in line as soon as you can. Don't wait. File now. Thank you for listening to this program. DACA is alive for now, the English version of Para Ser Legal. If you like this video, please subscribe below. If you have any questions, give us a call, and do us a favor. Share this video with anybody you think would benefit from learning more about DACA. Until next time, I'm Andres Mejer.